Hi, everyone. Welcome to the show today. I'm immigration lawyer John Khosravi. Welcome. It's December 1st, 2021, the last month of 2021. We are here for our regular weekly Wednesday, 6 p.m. Pacific time educational period, talking about U.S. immigration live on YouTube, on TikTok, on Facebook, on LinkedIn, and a lot more places. Plus, you'll find the recording, the clips of this on all the pages, in particular YouTube. Before we start, I want to remind everyone who's watching the live show, and for those watching recorded, to catch the live show on Wednesdays, 6 p.m. Pacific time, because we give out 3 free consultations, 15-minute video consultations for those who watch. While you participate in the raffle is, if you're watching live, you like, subscribe, and you write a comment saying consultations, and my wonderful assistant Katrina will announce a winner every 10, to me at least, behind the scenes, in 10 minutes, 20 minutes, and at the 30-minute mark. So you'll be able to watch that, be able to hook up and connect with me to get that free consultation. So definitely join in. We have a lot of happy people do that, and a lot of our regulars. Also, other than that, if you're interested in a marriage green card case, a fiance visa, there's a lot you need to know. The best way to get free information on that, really thorough information, is to download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com, and learn about that. Download the PDF that has all that information. You're going to get a lot of good information that's going to help you out and teach you about the process. And with that, let's get the show started. All right, as people are starting to trickle in and ask their questions, I want to thank everyone who's joining. It's a troubling kind of week. We hear about this new COVID-19 variant that emerged, calling it Omicron now. Well, the situation is, as always, everything affects U.S. immigration. So there is a travel ban announced for several countries in Africa, and it's similar to the previous travel bans, whereas if you had been to that country within the last 2 weeks, you're not allowed to enter the United States. But if you have a visa, say you're South African and you have a visa, or not even South Africa, but you've been to South Africa, you can wait outside for 2 weeks in another country that's not on a ban list for being able to return to the United States or come to the United States. But practically speaking, it's going to be hard if you're in those countries to even get a visa. There was a recent court case that said the embassies have to still issue the visa, even though you can't enter if you've recently been in those countries. But practically speaking, again, these embassies are probably going to shut down or be low staff and not even do visa interviews. So it's going to be hard to get one. And we have situations where people in the United States who need to leave, for example, they're on H-1B work visas. If they want to re-enter, they have to get a new H-1B visa. But I have a South African client who I can't recommend leaving because he won't be able to get a visa interview probably, and he'll be banned from coming in. So he's stuck here and he can't visit his family and do some stuff he needs to do in South Africa. That's the situation there. But it's unfortunate how this stuff works. Now we have our first question from Muhammad Madir. How much time does it take for USCIS to approve an I-360 religious worker at California Service Center? Well, what you should do is go to uscis.gov and follow the links to get their processing times, and they'll give you an estimate of what their processing times are. Having said that, they're completely unreliable processing times. So the true answer, the honest answer, and it will give you about a question like an I-360 for religious worker right now, is there is no answer. So you just have to submit it and make sure it's properly done and hope for the best. But there's no real good answer to what timelines are looking like on those. So definitely there's just something you got to deal with and hope that it's sooner rather than later. But that just goes to the timelines. Now, with regard to how long things take, it's different based on the service center, and within that service center, it's going to be different too, because you might get some officers who are faster and some who are slower. Now, when it comes to things like adjustment of status, if you're doing a marriage case where an interview is required, I'm getting these done really fast in Los Angeles, sometimes as quick as 3 to 6 months. But I have cases in San Francisco that are taking a year or more. So it's really inconsistent. San Jose just got really fast. They're hitting the 3 to 6 month mark recently. Had a case in, they lived in Illinois, but they had their interview in St. Louis, Missouri. And that took around like 5 or 6 months. So sometimes it's fast. It's so fast that the work permits and trial permissions don't even come. So we got a couple questions. Singh asked, hey, I'm a conditional green card holder, which is expiring in February, mid-February, and divorce is in process. So that gets a really troublesome spot when you're doing a removal of conditions. When you're in a process. So let's back up, see what removal of conditions is for those watching new. If you're getting your green card based on marriage to a U.S. citizen or green card holder, if the green card is approved within 2 years of your marriage date, they issue you a 2-year green card instead of a 10-year green card. And the reason is after 2 years, when the card's about to expire, they want you to submit another application Form I-751 to say that this relationship was real and prove it. Now, typically, people are still in a relationship and they may have children, they may have property together. There's all these documentation they can submit, but sometimes they get divorced. Now, you need to have all the documentation to prove your relationship. So you need to have accumulate documents to help prove it. Maybe have personal statements or something like that. And you may have an interview. But if you're going to get divorced, USCIS cannot make a final determination on the case, and they can deny it if your divorce is not finalized by the time they adjudicate it. So in your scenario right now being December, and you have your green card expires in February, and your divorce not finalized, you can submit the Form I-751 as a solo single in the sense of not having your spouse sign it. But you will get a request for evidence if by the time you submit the case, your divorce not finalized, and you'll get a request for evidence saying, hey, we want the final divorce certificate before we could approve the case or move forward. And hopefully by that time you'll have it. Now, when you do what's called the case, what do they call it? It's not a waiver case. For I-751, solo without the spouse, there is no necessarily end time to do it, but you really want to file it before the green card expires to be safe, and then just speed up that divorce and try to get it in so that when they ask for the divorce certificate, it's there. If they do an RFE, you could potentially say, listen, let me come to the interview and I'll show you the divorce certificate because it's not finalized. Here's the court order showing it's happening. But it gets really messy, and those are the times you hire an immigration attorney. That stuff I just said right now is general information. I need to know more about your specific case, a lot of different factors. But I just want to give a general overview of the troubles that happen when you are getting divorced midway in, you're starting or midway in the removal of conditions I-751 process. It's not clean. So unfortunately, you're going to have to deal with some headache. Tony Mauri says, hi, John. How long does it take to get a welcome letter from the National Visa Center after your I-824 is approved? Montreal Consulate, thanks as always. Oh, Tony, one of our regulars. I'm glad your I-824 was approved. How long does it take? It should take no more than 2 weeks, sometimes 2 months. But between 2 weeks and 2 months, but it could be as fast as 2 weeks. But the I-24, let me back it up, is for when you have a case that's begun in the United States and it needs to finish overseas, to have the case transferred overseas, that you submit I-824. The problem is, even though it's approved, doesn't necessarily mean USCIS will take the necessary steps to have the case sent out, even though that's what you paid for when you submitted from I-824. So hopefully, wait 2 weeks to 2 months. If that passes, contact the National Visa Center and say, hey, what's going on? The National Visa Center has been kind of slow in responding recently. And if they respond saying we don't have the file, then you got to contact USCIS and follow up with them. You might as well do that at the beginning. Just call, email, do whatever you can to get the ball rolling. But I have seen it many times with I-24, even though approved, just gets stuck and doesn't move forward. So unfortunately, that's the scenario with that. We have a question from Italo. My O1 visa is expiring in January 24. I'm already applying for E3. EB3, I submitted the I-140 and I-45 and EAD card. Should I renew my O1 visa or not? Well, it's up to you. That goes into case-specific advice for me to tell you whether to renew a visa or not. I don't know anything about you. If you feel like spending the money, you might as well. If you're really sure that your I-140, I-45 is going to go through, then you don't have to. But it's a good backup to have. So generally, it's recommended that you continue the O1. But I can't give you an individual advice because I don't really know enough about your case. But hopefully the rest will go through. It's going to be a personal decision and money decision, how much you want to spend on it, and if your sponsor is going to feel like doing all this kind of stuff, or if the sponsor is the petition agency. We have a question from Siraj. Hi, how are you? I'm doing good. I want to ask if the husband case is with USCIS and wife is pregnant, USCIS. Read next comment. Okay. And wife is pregnant, can we make an expedite request? Well, yeah, you can always make an expedite request. Whether they're going to approve it or not, that's up to them, but you can always make the request. So sure, the answer is yes, but whether it's approved, then it's not up to me. But hey, give it a shot. Doc25 asks, what if you get divorced, but you're not working? I'm a student and no kids. Am I eligible for alimony? Well, this is an immigration law show, not a family law show. We do family-based immigration, but you should consult with a local attorney in your state for questions about alimony and divorce and that kind of stuff. That's not something I can answer here, but I wish you the best with your situation. Io asks, hi, I'm working on OPT, but I just fought for adjustment of status of my green card holder wife. Congrats. If the I-7565, that's the work permit, gets approved, can I work elsewhere with the new I-765 or wait till I-485 gets approved? So if you have an adjustment of status, a green card case pending, and you file for a work permit, then and the work permit's approved and you get it, you could use that work permit to work anywhere you want. When you do work anywhere you want, potentially that cancels out your LPT and your F1. But if you got a solid case, a marriage case, I don't know your individual case. We've talked before here on the show. I haven't talked with you guys in private, so and to review your case. So yeah, but if you do get the work permit, it's open ended. You can work everywhere with the adjustment of status category C9 work permit. So that's doable. 29 Super C, our regular. Hi, Attorney Khosravi. Hope you're doing well. Same to you. The interview went well. Unfortunately, I didn't have my labor certification, but mailed it to him a few hours after the interview. I hope I'm successful. I'm sure you are. I'm surprised they asked for that because they probably have a copy already. But, this is embassies want different things all the time. I'm so happy you got your interview. This gentleman has waited and waited for his home embassy, U.S. embassy in his home country to get an interview. They finally did after much delay. And so finally the interview, hopefully they finalize and let you know soon and don't delay it too much. And you make your way over here to continue your life in the United States. But good news, so we have 29 Super C. Please keep me posted on what's going on. Cardus asks, how long are I-618 taking to get approved? Well, whether approved or denied, I can't say, but they're taking over a year. So it's going to be a while. And each case is different. Some are faster, some are slower. But these cases could take over a year easily right now. Next question is from Doc25. Oh, another question. My citizenship application is under process. I applied in March 2020, but didn't hear back. So if, I don't know the rest of it, but March 2020, that's a long time. That's a year and a half you've been waiting. I'm not sure. Check the local processing times for your field office. And if you're outside, contact USCIS to see what's going on. I'm not sure why it's taking that long. If you're sure you did March 2020, and right now it's December 2021, that's straight up like 12/9. It's 21 months. It seems pretty bad. So I don't know what your local field office of the continued situation is, but that's something. Now you have follow up with the question: if I get divorced before the decision is made, is that going to affect it? Well, that depends. Are you applying for citizenship based on a 3-year green card or a 5-year green card? If it's a 3-year, yeah, it's going to be a major issue. They're going to deny the case for divorce. So that's as easy. So when you file for citizenship based on marriage, a 3-year marriage kind of thing, you have to stay married and not divorced until after doing your oath ceremony or interview, oath ceremony, getting the naturalization certificate, then getting divorced. If you get divorced before that, it invalidates the 3-year aspect of it and becomes a problem. Now, if you've been waiting for so long, at the end of the day, yeah, so it's going to be a mess. Hopefully, you just did 5-year and won't have that problem. So Ed Cabral asks, any info on a B1, B2 visa getting revoked due to getting vaccine in the U.S. seen as public charge? I haven't heard of that. I'm not sure if they would call that a public charge if you got the vaccine. I don't even know how they would know. Now, if you use like straight up health services, like in a hospital or something, they won't revoke it necessarily, but they can hassle you potentially. It's not an automatic revocation kind of thing. I doubt. I mean, it's up to these people. I doubt they would say you got a free vaccine, they'll hold it against you. If anything, they want to push these vaccines. So it's not up to me. It's discretion, but I would highly doubt it. And I don't even think it would come up. So just getting a vaccine, to me, doesn't seem like something to worry about. I wouldn't worry about it, but hey, it's not up to me. But in general, I wouldn't lose any sleep over something like that. Then again, one note is I didn't know if you fill out paperwork saying you're a U.S. citizen or you got a bunch of other stuff. So again, I can't provide case specific or unique information to you because I haven't seen exactly what happened. But generally speaking, this is all general education over here. All right, next question from a regular IO. If the work permit comes out, says my wife is a green card holder and I'm working on OPT, will I be out of status before I-485 comes out? Yeah, I mean, once you file for adjustment of status from I-485, if you fall out of status afterwards due to now maintaining status, like your tourist visa expires, your OPT expires, it's okay. You're out of status, but you're in what's called a period of authorized stay, which means you can stay here until USCIS makes a decision. Now, if your case is denied, that's bad news. But if it's not denied and it's approved, then it doesn't matter. If you maintain your OPT and you're not out of status, but eventually OPT is going to run out, so that's going to end. So overall, if you have a case pending and it's a good case, I wouldn't really be worried about that. But I would need to just talk with you to review all of the docs to be able to, give more certainty about that. I'll be doing our regulars. Hi, my B2 I94 will expire in January 2022. My I-45 approved today, and I already have I-45 is pending. What do I need to do now? If you have an adjustment of status pending already, nothing. I'd be worried if you file for adjustment of status really soon. If you came on a tourist visa, that might seem suspicious that you file for adjustment of status while on a tourist visa on an I-140 in particular, knowing that you did the perm process, all that. But sometimes people's plans change. You have to see the unique circumstances. But if you, as I answered in the other question, if you have an adjustment of status from I-485 pending, then it's all good if your previous I-94 expires, your status expires, because you can stay here until a decision is made on your case. Cardez asks, my husband is from Guatemala, has a family emergency. Can we expedite for humanitarian purposes I-601A? You can always make the request, just like the previous person. You can always make the request about expedites. It's up to them whether they're going to accept it. They're kind of difficult about it, but sometimes it works. It's just luck, really. So if you want to give it a shot, it may work, So next question, Annas asks, how long? Hi, do you know how long does consular processing for London embassy will take for U.S. citizen? I assume you mean the U.S. citizen marriage. No, it just depends on whenever they get around to you. So U.S. embassy in London is a really busy one. They're super backed up because of what happened during the coronavirus. It just depends on whenever they get around to you. Expect delays in the process. And in general, there's no answer a person can give. And then I could say 6 months, 3 months, but it could be either or something completely differently. So in these kind of cases, you just got to be patient. And that's about it. The whole embassy system, Department of State, is completely messed up right now. A lot of places are closed. A lot of places are backed up. When it comes to London, there are just probably tens of thousands, not 100,000 cases of people who are trying to get these waivers to be able to come in, and they're missing that. Quick note, I want to announce our winner for the free raffle, Doc 25. I think you had asked some questions about, I can't remember what questions it were, but if you'd like to schedule a time talking about citizenship pending that long, just take a screenshot of where you're watching this and include so I can see your username, and then email it to me at info@jqqlaw.com. I think you're watching on TikTok. Take a screenshot so I know it's you, and email it to me at info@jqqlaw.com. And that way I could send you a link to schedule a free 15-minute video consultation. So in private, we can talk about your case. For those just tuning in, we're giving out free video consultations. Just write like, subscribe, wherever you're watching this, and type in consultation. And my assistant Katrina will announce a winner about like 10 minutes or so, and you'll get a chance. You'll get a free video consultation, 15 minutes. We'll talk about your case and get into it. I think you'll get a lot of value out of that one. It just goes to show, like, when you're going into this kind of stuff, when you're talking about immigration, there's just so many little things we have to talk about. Even the 15 minutes sometimes isn't enough because it gets really deep. There's just so many levels of documentation and errors that could happen that we got to double check all of it. The process, unfortunately, is super complicated when it comes to immigration because there's just so much large volume of information. And so that large volume of information, paperwork, and all this kind of stuff leads to errors everywhere. USCIS can make errors, attorney can make errors, client can make errors, forget about stuff, and then remember it later on. Their documents could have errors on it. I talk about this a lot, but I've so many times I look at those birth certificates and there's errors on it, or it was printed out or registered really late after birth, which creates questions for USCIS. So we always have to look at all this stuff, and it's hard to just give a quick answer. We really got to sit down and analyze stuff. And sometimes we could start working on the case in a couple of hours into it, a week or two into it, and all of a sudden discover an error. But that's just a job of just getting into it and see what's going on. So I'm doing follows up. Thanks. I came to US in July 2021, and the I-140, I-485 were filed early November. August, September, October. I hope that's not too soon. Schedule A. Okay, Schedule A. That makes more sense that you didn't know. The Schedule A is an exception that they have for U.S. of people who have certain jobs that are so needed that they don't have to go through the full employment-based green card process, and you can do it faster. And that's why you're able to file the I-140 so fast, and you may have just found a job during that time. So it's not as bad as I thought it was. I'll be doing because you're Schedule A. But thanks for letting me know. Overall, they're probably gonna be cool with it. Now, if you filed in July 2021, you came in, so filed early November. Okay, it's gonna be another year at least until things get moving for you. They're so slow. Hopefully it's faster, but it's taking a bit to get these done. So yeah, the timeline situation is always really uncomfortable. 29 Super C asks, a point note to embassy today, it had quite a bit of candidates for employment-based immigrant visas. seems this is a sign of trying to reduce the backlogs for the tier 4 in the embassy. Yeah, that's the Department of State did make an announcement that they'll leave it up to the embassies to create their own priority system. And it seems like the U.S. Embassy you're at is making a priority to get these employment-based cases out of the way. I mean, I know you've talked before, but it's not one of those. It's not the busiest embassy, so they might have probably more candidates in different categories they could just rush through. But a lot of times they make priorities marriage cases and children of U.S. citizens or green card holders. But it's up to them to see what kind of priority they want to do. And I'm glad you're able to get your interview. It's good news. Make Cash Now asks 6 months after marriage green card of my brother. The green card is not out. Few months to be 2 years. Got married to U.S. citizen inside the United States. I don't know exactly what you mean because you're saying 6 months after marriage green card of my brother, so the green card is not out. So you mean after it was approved? Do you mean after filing? I don't really know what's going on. So your brother needs to talk with someone in private, or just you need to word the question a little better so I could better understand it. But sometimes it takes a while for it to be sent out or approved. I don't know. Maybe you need to contact USCIS. Even if you ask the question in a different way, I need to know more info. And at the end of the day, maybe that won't be able to answer that. I need to talk with you, or you have to call USCIS to see what's going on. So that's just the way it is. When we go to these interviews, I have 2 cases right now that are open and shut cases. One a citizenship case and one a marriage case. And both of them, 3 weeks after the interview, they're still not approved. And it's really annoying and worrisome for the clients. But I know the cases, I know there's no issues, but it is annoying when that happens. When you do an interview and it should be done, citizenship should be granted, the marriage green card should be granted, and it's not. Sometimes just the systems aren't right. There's confusion. The officer might have lost something or not sure what to do. And so we try to refresh their memory. I try sending them a letter after 30 days. Say, hey, do you remember us? What's going on? And a lot of times that pushes it through. But fortunately, it's an unreliable system. So, but you just really want, the most important thing as an attorney is to prepare the case well. So try to spot anything that's potentially an issue and be prepared for it. And then leave the rest up to God and this officer to get it through. But you just don't want to get any surprises later on, oh, we didn't catch that or something like that. That's always going to be a messed up situation. So we got some more questions. Sunny asks, how to change social after getting green card. I don't know what, I assume you mean social security card, and there's no changing it. Your social security card is your social security card. You contact the social security office if it's been fraud or something like that and you need to change it. My focus is on U.S. immigration law. I don't focus on social security law, but that will be it. Make Cash Now as what qualifies 10-year marriage green card, the first issuance of the green card? Yeah, so we talked about this earlier, but if you do green card based on marriage, potentially they'll give you a 2-year green card. And to be able to get the 10-year green card, if you had a 2-year green card, you have to file an application and request it. But to prevent the 2-year green card in the first place, the day of the issuance of the green card has to be after 2 years after the marriage occurs. So if marriage occurred January 1st, 2020, the green card has to be printed out, January 2nd, 2022. And so if you're in the United States, it's going to depend on when they approve the green card mailed to you. If you're from outside the United States coming in from consular processing, the day you enter at the airport, your admission date is the date they look at. So a lot of times I've had cases where the case took 1 year and 10 months to get approved at the embassy. I'll tell clients, hey, hold off on coming to the United States for 2 months, pass the 2-year mark, then enter the United States to avoid having to do Form I-751 removal of conditions and getting the 2-year green card. That way, just go straight for the goal, get a 10-year green card, and not deal with it. So that happens as well. Now, I do want to announce Make Cash Now. You're a second winner of the video consultations. Take a screenshot of where you're watching this and email it to me at info@jqqlaw.com, and we'll schedule a private video consultation. Again, that's info@jqqlaw.com for those just tuning in. If you're watching a live program, subscribe, and write. Consultation in my wonderful system. We have one more that's going to pop up, one more person that we give free video consultation to. So just follow the instructions and do that. And also, if you're thinking about doing a marriage case and learning about this stuff, just download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com, marriageimmigrationlaw.com, and down the ebook is going to help you out a lot. All right, I think I have 1 or 2 more questions. Is having PTSD a reason to expedite the case for interviews? Well, it depends on who has the PTSD. If there's a foreign person, you got to make sure it's not going to create some sort of medical inadmissibility issue. But I don't know. I mean, just saying I have PTSD. Do you have documentation of that? Do you have evidence of it? How does that affect being separated from like the spouse? So just telling me in a sense like that doesn't do me anything. I need to dive in deep to see what it is and do the same kind of review USCIS may do. So it may not. I can't answer that without reviewing the case in detail. Even then, it's not up to me. It's up to the discretion of an officer. So it's up to them. User 808 asks, pending asylum case, can I travel with advanced parole to another home country, to other than home country for a short trip? Well, you'll need to get a refugee travel document. If you have pending asylum case, I don't know if they're going to give it. You can always try getting advanced parole. You could apply for it, and if they want to approve it, they can approve it. There's a problem that you'll need a passport to travel, and they don't want you to use the passport for the home country. So I just wouldn't advise traveling. Now, I don't do asylum case in many years, not my specialty, but generally, if you have a pending asylum case, I know it's probably taking forever, but I wouldn't recommend flying outside the United States. You don't know what kind of situation you're going to be dealing with if you leave and come back. You might have to use your passport, which is not supposed to happen. So there's a lot of issues baked in that case. So how many times, Kanan Shah asked, how many times can you apply for a motion to reopen after first denial of application by USCIS? Well, it depends on what the motion is, what the bases are. I've read appeals cases where people did like 10 different motions to reopen and reconsider. But if it doesn't work out the first time, I mean, there's a bad chance you might file lawsuits, probably better. But we have to see what the reason is that you're filing this motion. So when you say how many times can you apply, well, if you have a factual basis or legal basis of mistake, potentially you could do it again. But I don't know if you're just going to do it just to do it, then it doesn't work. So these are not the kind of questions I can just say this. It depends on the facts with much of law. So we're going to be ending the show pretty soon. If you have some final questions, let me know. We have one more that's jumped up. Kate Perda asks, my fiance came here to USCIS as a visa holder and overstayed. Can he stay and do his process here? Oh, I don't know. I mean, if you enter lawfully, that's a good sign. If you're a U.S. citizen and you're getting married, that could help. Overstaying is no problem. But I would need to know about his background. Download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. You'll see what I'm talking about. And, you know, if you like, just take a screenshot of where you're watching this and email it to me. You're watching on TikTok and email it to me at info@jqqlaw.com. That's my email address, info@jqqlaw.com. And we'll schedule a private call just to get some basics of what's going on. But in your case, if you enter lawfully, no criminal history, affidavits of works, you have good bona fides and proof of relationship, potentially, yeah, they can file for a green card here once you're married. But I need to check out that stuff more in detail. So definitely, you win of our third and final raffle for the day. Just take a screenshot where you're watching this, email it to me, and we'll schedule it from there. I guess we'll leave off with this last comment by our regular 29 Super C. Have a good night, Attorney Khosravi. We'll let you know what the embassy decides on my application. Well, thank you so much, and I pray for good news. And God bless everybody. I really hope these delays at these embassies and 601 waivers, all this kind of stuff, doesn't happen. It goes down, and you're able to get your expedites. Praying for everybody. Until next week. God bless. Be safe, and we'll talk more of that. Bye-bye.